Conservators must post bond. I know we've covered some of this as well. That bond is an insurance, it's basically an insurance policy you buy against yourself so that if you screw up, the bonding company, Judge Wolk can tell the bonding company, okay, the conservator screwed up, you have to pay this money to me, to the court, and then the bonding company will come after you to collect on what they had to pay. If you cannot be bonded, do not ask to be conservator. Bonding is not optional if there are assets. And if you cannot get a bond, you cannot serve as the conservator. You can serve as the guardian. A guardian does not have to be bonded, but a conservator does have to be bonded.
And don't come into court and say, they tell me that they don't do this everywhere. They don't require bonds in other counties, because I know you're lying. And I don't care who they are that tell you that. They are not the judges. And we talk on emails, and we know that there are no theys. So, but there are rumors amongst people who serve that there is this non-existent county where you don't have to post bonds. And then people come in and say, well, I heard you can waive it if you need to. I can't. I don't have any discretion to waive it.
The law does not give the court discretion to waive the bonding requirement. It does give the court the discretion to, what the amount of the bond is, but it has to be at least 1 year's worth of income.
And the value of the asset, of the movable assets.
Yeah. I think real estate doesn't have to be bonded.
You can't steal dirt and take it to Mexico, so it'll still be in Georgia and we can get it back, theoretically.
Guardians and conservators, take an oath. If you are named the guardian, you raise your hand, you swear that you're going to perform your duties to the best of your ability, and then the court issues these magic pieces of paper called letters of guardianship and or letters of conservatorship. That shows your authority to act on behalf of that individual. You present that to the doctors, hospitals, insurance companies, schools, anybody who cares to look at them and is questioning your authority to act on behalf of that individual. You can even present it to police officers, district attorneys, even criminal court judges. Now, they might not care too much about it, but they will at least allow you to participate in whatever process your loved one might be going through.
Right here is you get an order from the court. The order does nothing. That nominates you. You are appointed. This is when you are qualified. You are not the guardian or the conservator until you get letters. You don't legally have authority to do anything. The rights are removed with the order. The rights are not transferred to you until you get your letters. Does that make sense? We have people all the time who take the order to the bank and try and set up an account. Sometimes they're successful, which stresses me out. And then we have people who try and take the order to a hospital. They aren't the guardian or the conservator yet. They are not that until they get that particular piece of paper.